Good morning, everyone. I'd like to extend a warm welcome to you all today. My name is Catherine Saxhorn, and I'm the Director of Marketing here at Home Care Assistance. Home Care Assistance is the leading provider of in-home care for seniors throughout the U.S., Canada, and Australia, helping over 100,000 families navigate their senior care options. I'm happy to present today's webinar, A Will is Not Enough, Everything You Need to Know About Estate Planning, led by Mark Gilfix, attorney at Gilfix and LaPole Associates and co-author of Facing the Reality of Long-Term Care. Mark cares deeply about generosity and community building in addition to connecting with people and helping them plan for a vibrant future. He currently practices in the areas of estate planning, elder law, and special needs planning in Palo Alto, California. He graduated from Stanford University with a degree in management science and engineering, and he later attended Loyola Law School's evening program, working full-time while obtaining a law degree. He is an increasingly sought-after speaker in the field, speaking at national legal conferences and appearing on television about these issues. You will notice that there is a chat screen on your window, and we are reserving the last 15 minutes for your questions. So please feel free to send in your questions throughout the presentation, and we will compile them throughout the call. I am now going to turn the presentation over to Mark.
All right. Well, thank you, Catherine. And I want to thank Home Care Assistance as well for having me here today. Our firm, I'm speaking from Palo Alto, California, right near Home Care Assistance headquarters, and our firm has a long and positive relationship with your company. We've had a lot of clients who've had great experiences with you guys, so we feel very good about working with you guys, and it's an honor to be able to be here today to speak to your community. So let me give you guys a quick overview. You can see this in front of you, hopefully, and I'm going to try to navigate these slides as we move forward. I may need help from the Home Care Assistance team in a second, but let me give you a quick overview about what I'm going to speak about today and the issues we're going to go through. So first, I'm going to give you a bit of additional information about who I am and where I come from. I want to introduce you to the bigger picture of what estate planning is all about and how you really need to think about it. I'm going to go then into the 3 documents that everyone really needs, and I'm going to go into some detail around those. I'm going to briefly talk about some long-term care issues. Obviously, that's very relevant in this world, in the world of home care assistance, because that really is what you guys do and what I would imagine most people calling in really care a lot about. I'm then going to provide some guidance on how you can speak about these issues, because it's one thing to understand how these documents work and what they do, but it's a whole other thing to actually have the discussions, have the conversations with your family to really put them into place the right way and to make sure these issues are properly dealt with. I'm then going to go through some specific steps of what I think you really should do right away coming out of this talk. So on that note, let me see if I'm going to try to, well, that did move forward, so that worked. Some quick additional information about me. As Catherine mentioned, I went to undergrad here in Palo Alto at Stanford Law School. I was born and raised here in Palo Alto, California, and then went to Loyola Law School. Graduated with a degree in law there a few years ago. But before that, I did a lot of stuff before I went back to law school. So coming out of Stanford, I was a management consultant. I did a lot of corporate strategy work with some Fortune 500 companies, including companies listed here, GM, Boeing, Lockheed Martin, and a bunch of others. I worked in the tech field, I worked for a major winery, a bunch of other companies. So I have a business background. I think about all this stuff with an analytical hat that I think some people don't have in this field. I was in Los Angeles as a management consultant, and this is, I think, somewhat unique among lawyers. I actually fell into the acting world for a while. I did some TV stuff, some commercials, some films, some viral YouTube videos. I dare anyone here listening to find those videos. They're not that easy if you just search for my name, but there's a lot out there if you can find them. And now I am an attorney. I work at Gilfix and LaPole Associates. I'm going to go into a little bit more background about our firm in just a second. But I come at this with what I believe to be is a pretty unique background, especially in the field of estate planning and elder law, and that informs how I think about this, and it informs how I think families should really think about these issues. Go to the next slide. So here are a couple images of me as an actor. On the left, it's probably one of the most high-profile commercial things that I did. It was introducing the iPhone 4S and introducing Siri to America. Some people love Siri, some people hate it. Please don't blame me for that. But I did help to introduce that to America. And on the right, that's it's still from I think that's from a Lenny Kravitz music video that I was the lead in. I shot a guy in the head as a part of this music video. So not quite the typical estate planning attorney. So as you listen to me, hopefully you're not picturing just a stodgy guy who's sitting with a bunch of books. I do read all those books. But again, I think about this stuff a little bit differently. Let's go to the next. Actually, I will try to go to the next slide here. There we go. So about our firm. I work at Gilfix and Lippold Associates. It is our family business. We were one of the nation's first estate planning firms. I was started by my parents, Michael and Myra Gilfix, after they graduated from Stanford Law School. But notably, it was started about 10 years after they graduated from law school, because they spent the first 10 years after law school creating and running the first free legal aid program for the elderly in America. It's SALA. It's called the Senior Adult Legal Assistance. And really, in creating this organization, Michael Gilfix helped to create the field of elder law. And he's written hundreds of articles and books. He speaks around the country, so he's really been my mentor. And that photo below is actually my mom, and that's me and my grandparents. So you're getting a good picture of where I come from. But our firm really, we focus on this stuff. We've served thousands and thousands of clients in this field. We do a lot of thinking, a lot of writing about this stuff. We speak a lot of conferences. So this is really where I come from. So, okay, let's transition to what is estate planning. You know enough about me. What are we talking about here? Formally, estate planning is about preparing for the transfer of a person's wealth and assets to the next generation or to their beneficiaries when they pass away. And sometimes before they pass away as well. But that's pretty dry, and it's kind of depressing to think of it that way, because that's just after you're gone. And that can be a positive thing. It can be something where you help out the next generation. But really, the way that we want people to think about it is it should be about bringing your family together and empowering your loved ones to care for you if needed and continuing a positive legacy. We think that estate planning should be about turning your fears about the latter parts of your life into hope. And very notably, we believe it should be about, whenever possible, staying out of the court system. I'm going to spend some time talking about what that means. But a lot of what we're talking about here is creating documents. They're not that complicated. I mean, there's a lot of legalese in them, and you can't really do them by yourself. But by doing these somewhat simple documents ahead of time, you can save so much pain, so much time, so much money down the road. So it's really about, again, empowering the people who you want to be involved in your life to help you out if you need it, rather than not doing anything and being at the whims, being stuck with the whims of the court system, so to speak, down the road. So it's something that if you plan ahead, it can also be a great excuse to bring your family together. We have a lot of clients where we act as sort of a third party to bring multiple generations together. And that's another thing that I'm going to talk about a little bit, the importance of and the value in bringing multiple generations together when you're thinking about estate planning, and the value of communicating, the value of planning ahead. So I'm going to talk a little bit about that as well. So why don't we go to the next slide? Great. There are 3 critical documents that really everyone should have. Now, I know there's some listeners from Canada, and I apologize that some of this stuff doesn't apply to Canada, and I'm not an expert on Canadian law. I did a little bit of research ahead of time. I believe 2 of the 3 documents are highly relevant in Canada, but tax laws are a little bit different. So some I'm going to talk about isn't exactly on point, but I think all this thinking should still inform how you plan ahead. But all this stuff absolutely is relevant in the United States. So for all you U.S. listeners, I think all of this is on point. 3 must-have documents. 1 is a revocable living trust, also generically known as a living trust, sometimes known as a revocable trust. There's a few different names that are used for this, but that is really the cornerstone of your estate planning. 2nd is a durable power of attorney document. I think a lot of people are generally familiar with that. I'm going to go into what that really means in a second. And 3rd is the Advanced Healthcare Directive. That has to do primarily with healthcare decision-making, as its name would suggest, whereas the first 2 documents, the Revocable Living Trust and Durable Power of Attorney, those really go more towards your financial planning and the financial side of things. I would bet some people in the audience have heard these terms before, have heard of trust, certainly, but I think there are a lot of misconceptions out there. I know I grew up in an estate planning family, as you guys all know now, because you know my family history, and I was confused about this stuff until I went to law school, and frankly, I was still confused up until I really practiced in this area. The term trust is so loaded. I used to picture just billionaire families sitting back with their trusts and their trust funds and with their teams of lawyers helping them to set these up. And that's really not, there are those types of trusts. But what I'm talking about here is something that really is relevant for everybody. These are not just for the ultra wealthy. They are not just for people even with kids. Even if you don't have kids, or even if you aren't sure where you want your money to go down the road, there are still very good reasons for having each of these 3 documents, and most specifically the living trust. And again, the goal with all of this is to maintain control, and in doing that, it's to gain peace of mind. And really all of these are about taking control of your future and making sure, again, that the people who you want involved in your life down the road are going to be empowered to be there for you. Let's go to the next slide. All right, some rules to be aware of. Estate and gift taxes. I think there's some misinformation out there about that as well. But right now, I'm talking about federal taxes, first of all. Some states have their own state-specific estate taxes. Here in California, we don't have one. So depending on which state you're in, you should double check and see if your state has an estate tax. But from federal rules, this applies to everybody in the United States. You can pass up to $5.45 million per person. So between a couple, provided you make the right filings with the IRS, you can pass almost $11 million to your heirs when you pass away or via gifts while you're alive with 0 estate or gift taxes. So that's a lot of money. It doesn't affect many people. And so that rule has changed actually pretty dramatically in the last few years. So this is one reason why, if anybody listening, if you did a trust or did some estate planning years ago, this is one reason to revisit it. Because this number has gotten bigger and bigger, and there are a lot of implications. I'm not really going to go much into tax planning. That's kind of out of the realm of what this talk is about. But there are very good reasons to revisit older trusts for tax planning, if nothing else, because a lot of trusts were set up assuming that you couldn't pass nearly as much money to the next generation. And so there were a lot of tools in place that really are unnecessary now and put some restrictions on how the trusts would operate that you just don't need now and sometimes can actually be negative. So the point here, though, is very few people have to worry about this. Frankly, if you do have to worry about it, it's a good problem to have. There are a lot of steps you can take to reduce your exposure, even if you do have an estate that exceeds $11 million. But again, outside of the realm of this talk, but just to point out, very few people have to worry about that these days. There's also the annual gift exemption amount. Any person can give up to $14,000 a year to as many individuals as they want without reporting it to the IRS. So if you have 10 friends you want to give money away to, you could give each of them $14,000 a year, and you don't even have to mention it to the IRS. Now, if you go over that $14,000, you don't have to necessarily pay any taxes. You just have to report it to the IRS. You have to say, hey, I gave money against my $5.45 million lifetime exemption amount, so just make a note of that, IRS. It's, I'm down a few $1,000s, but you don't have to pay any taxes on it. Another thing I'll point out is the receipt of a gift or the receipt of an inheritance is not taxable for the beneficiary. One thing I should point out is in Canada, again, my understanding is limited, but Canada doesn't operate the same way. I believe in Canada, they treat it kind of like capital gains taxes. So my understanding, and if you are in Canada, certainly speak with an expert there. But my understanding is when someone passes away, their assets are treated as if they're sold. So let's say they have a house that's worth $200,000, they paid $100,000 for it. When it goes to their kids, I believe the estate would be responsible for taxes on the gain in value in the house, that $100,000 gain. So I don't think there's an exemption amount, but there are some rules you need to be aware of in Canada. And I believe all the other stuff I'm talking about with court involvement, they might not have all the same terms in Canada, but I believe all the same concepts are absolutely relevant. So another rule, and I stated it as a rule because I think you should think of it this way, avoid court whenever possible. What do I mean in this context? We're talking really about probate and conservatorships. Very quickly, I have a bullet point here about probate. Probate comes into play when you just do a will. Hence my title, A Will Is Not Enough. If you just do a will and you say, I am leaving my assets to my son and my daughter in equal shares, if it's just a will, a court has to oversee the distribution of those assets. And for a lot of reasons, you don't want that. It's public. Anybody can take a look at your will and what you have. It takes forever. You're at the mercy of the court schedule. And here in California, you don't want that. Some states maybe are better than here, but in no case is it a pleasant process. And the fees are extraordinarily high, and they're set by court. You can't negotiate them down. They are double to triple the fees that it costs if you can avoid probate via a trust, I'm going to talk about in a second. A conservatorship is not the same thing. It's basically conservatorship comes into play if you can't manage things for yourself and someone else needs to come in and manage your financial affairs, your bank accounts, things like that. If you haven't named someone in a document, in a trust, a durable power of attorney, you need to go to court. And a court needs to give someone the power to manage your affairs for you. Again, that process sucks for a lot of reasons. I'm going to go into some of those in a little bit. So why don't we transition to the next slide. So here, let's go into these documents. The first document I'm going to talk about is a living trust, or a revocable living trust, or a revocable trust. Again, different terms are used for this, but the concepts are all the same. So what is a living trust? Well, it's kind of like a will, but it's a lot better. The way I like to talk about it with our clients is it's a way of privatizing your estate. What does that mean? You create this document, you transfer assets into it. It sounds very formal. It sounds, again, like those billionaires who have these trust funds and all that. They're really not that complicated. It's basically creating a private agreement that governs your assets, basically. So you create a trust. You do have to retitle your major assets into the trust. Like if you own a home, you would do a deed to transfer ownership of the home. So for me, let's say right now I have a house. It's owned as Mark Gilfix. I'm the owner. If I create a trust, I create the Mark Gilfix Trust. I would simply transfer my home so it's now owned by Mark Gilfix, trustee of the Mark Gilfix Trust. There are some good reasons for doing that. Primarily, this means that I can name, when in creating this trust, who manages my assets. So when you set up a trust, you are your own trustee, like 95% of the time, unless someone has medical issues or some dementia issues. When you set up the trust, you are the manager of these assets, but you get to name the individuals who can take over if you can't manage. So I get to name successor trustees for my trust. That means if I'm ever incapacitated but still alive, the people who I name there get to take over management. They don't have to go to court to take over management. They don't have to get a court order to give them the authority to manage my assets. They simply have to show that I can't do it, or I can voluntarily step down. But the point is I get to name the people who can manage my affairs if I can't do it. A trust also directs where my assets will go after I pass away, just like a will. So in the trust, I would say to my kids if I have any kids, or to my siblings if I don't have kids, or however you want to do it. And very notably, a living trust avoids probate, that court process that I just talked about. Now this is United States focused. In Canada, I'm not sure how this would apply there. I think, again, the rules are a little bit different. But anywhere in the United States, if you do a trust and you properly fund it, you retitle your assets into the trust, which is not that difficult to process. It's a little bit of a pain, but it's really just a few hours of paperwork, and you're done. As long as it's in the trust, you don't have to go to the court system. Your assets will go to your beneficiaries privately. You don't have to have a judge sign off on it. You don't have to pay the probate fees. It's done outside of the public sphere, and it's much better than going through probate. And also, additionally, I talked about conservatorships, and I've talked about this a little bit. If you become incapacitated, and if you can't manage things for yourself, in a trust, you've already named the people who can take over management of your affairs, and they can do it pretty seamlessly. They don't have to go to court again. And we all remember that rule from the previous slide: avoid court at all costs. And we get the question sometimes from people who are unmarried or don't have kids. They say, well, why would I do a trust? I don't care about probate. So what? I'm leaving my money to a charity, or I'm leaving it to distant relatives. I don't care about if they have to deal with probate. So who cares? We say it's still very important to have a living trust because of these lifetime management benefits. The fact that if something happens to you, a trust ensures that your major assets will be seamlessly taken over by the people who you choose. Again, if your stuff goes, if a conservatorship is needed, if a court is needed to appoint someone to manage your affairs, if you haven't named them in a trust or a durable power of attorney, which I'm going to go into in a second, you're at the whims of a court. They might not name the people who you'd want managing your affairs. They would choose who they think is best. But this is a third party who doesn't know much about you. So you might think that, oh, I'd love to have my sister take over for me if I can't manage things. But if it goes to a court, they might disagree. They might appoint some random third party. The point being, having a trust is a way to really take control of your affairs and make sure the right people are named. So let me just go through some of the basic mechanics of a living trust. I talked about this a little bit, but when you set up a trust, you as a creator of the trust, you're known as the settlor. So that just means you create the trust and you put assets into it. And don't get too hung up on this stuff. It's not that important. I just want to give an overview if you ever hear these terms thrown around. So let's say I create a trust, the Mark Gilfix Trust. I am the settlor of my trust. I'm creating it. I'm defining its terms. I'm also funding it. The trustee, the trustees are the person selected by me, the settlor, to manage trust assets. Now, for a revocable living trust, hopefully I mentioned this before, but you can change them at any time, by the way. So you can, once you set up your trust, you can restate it. You can change the people named. You can change where your assets are going. Nothing is set in stone. You can make as many changes as you want. We have some clients who have made 8 updates to their trusts over the years. So as the law changes, you can change the structure. As your people in your life come into your life or go out of your life, you can replace people. You can swap them out. There's unlimited flexibility. So when you set it up, though, you do name your successor trustees. Again, these can be changed at any point. But typically, again, 95% of the time, when you create a trust, you are your own trustee. So I create the Mark Gilfix Trust. I, Mark Gilfix, am my own trustee, but then I might name my father, Michael Gilfix, and my mother, Myra Gilfix, as my successor trustee. So if something happens to me, they can step in and manage things for me, but they only step in if I can't do it. The trust itself is the written document that contains the specific provisions defining who these successor trustees are and the terms of the trust, and very notably, the beneficiaries of the trust, where my stuff is going to go after I'm gone. Another benefit of a trust versus a will, aside from the fact that you get to avoid probate, aside from the fact that you get to name individuals who can take over for you while you're alive, is a trust. You can build in a lot of different structures for how your assets go to the next generation or to your beneficiaries. If you have young children, what happens if something happens to you before they're 18 years old or before they're 25 years old? Do you want them to inherit everything right away? Wills, there probably are ways to build in some protections in wills, but when creating a revocable living trust, there are a lot of ways to build in restrictions and protections for how your beneficiaries will inherit. So you can make sure your kids don't inherit before they're 25 years old or before they're 30 years old, or they only get a little bit before they're of age, because I don't think anybody would disagree with the idea that it's not such a good idea for an 18-year-old to come into a bunch of money. I don't know about you, but I probably would not have made the best decisions with a few $100,000 on the day I turned 18. So a trust can also build in a lot of protections there. So quick comparison between wills and trusts. I'm hitting this on the head a lot. I know I'm going through this a lot, but I think it's really important. If you just do a will, your estate will go through a court-supervised probate. If you do a trust, a court does not need to be involved. A probate process is extraordinarily expensive. A trust administration, which is what happens again if you have a trust, the costs are much lower, typically a half or even less of the cost of a probate. Everything about a will becomes public after you pass away. A trust is completely private. Nobody has a right to see it. One thing I like to point out is anytime you hear a celebrity, celebrity passes away. I think Philip Seymour Hoffman was a year or two ago, tragically passed away from a drug overdose. And all of a sudden articles started coming out about how much he had and how much he was leaving to his kids. And you're thinking, wait, why do we get to hear about this? What business of this is ours? And I don't know for sure, but I'm 95% sure it's because Mr. Hoffman only did a will. He didn't do a trust. So everything about his family, everything about his assets was public because it had to be, because it was part of the court process. Had he done a trust, it wouldn't have been. So now, most of us here probably are not as famous as he was, so our estates probably wouldn't make headlines. But suffice it to say, I think most of us would prefer that stays private. Again, a probate can take forever. Sometimes it can take up to 2 years or more. A trust administration process can be much quicker. They still take a few months, but it's really up to how much effort you put in working with a professional to get it done. A will is only effective at death. You name an executor in a will, but the executor only is involved once you're gone, where the trust allows for lifetime management help. A will also, if you have property in multiple states, let's say you live in California, but you have a vacation cabin in Arizona. If you just do a will, you're going to have to do a probate in California, and you're going to have to do a probate in Arizona. So if you have property in multiple states, you're going to have to do probates in every single state where you have property above a certain level. Having a trust avoids all of that. All right, enough about a trust, and if people have questions about those, I'm happy to answer those at the end. Again, I think Catherine will be running a 15-minute Q&A at the very end where we can go into any questions you might have. The durable power of attorney. So this is a document that it overlaps a bit with your living trust. Notably, a durable power of attorney only applies while you're alive, whereas a trust is while you're alive, you're gone. The durable power of attorney allows you to name the individuals who take over for your financial and business affairs if you can't. As I put here, the business of life stuff. So day-to-day things, because your trust manages your big assets. So a trust, you typically will put your home, if you own a home, you'll put your investment accounts, your large bank accounts, savings accounts, things like that will be in your trust. So your successor trustee, if you're incapacitated, if you're in an accident, or if you have medical issues, or if you have dementia issues, your successor trustee can manage those things. But there's a lot of stuff that doesn't fall into those categories. Day-to-day bill paying, your utility payments. If you have a business, running a business, some real estate management issues, collecting rents if you have a rental property. So having the durable power of attorney allows you, again, to name the individuals who can take over for those issues and those items. You get to decide how much power and flexibility you want to grant to those individuals. We know a lot of clients come in with very simple durable power of attorney forms they've done either on their own or with attorneys who don't specialize in this. They kind of just check off boxes and say, I grant this power, this power, this power, this power, and this. That's okay. It can work. We always suggest doing a more sophisticated version, though, where you have a little bit more specificity built in. But either way, it's important to have this document just to make sure that, again, if something happens to you and there are financial matters or business affairs out there that aren't covered by, even if you do a trust, you still need to do this because there's stuff that doesn't fall into your trust. And if you don't have a trust and if you don't have a durable power of attorney, something happens to you, who takes over? Who gets to go to the bank to take money out to pay your bills? Someone would have to go to court. And they, again, would have to get a conservatorship, basically go to a judge and say, Your Honor, Mark Gilfix was in an accident. He can't manage his affairs. Here are documents showing that he can't manage his affairs. We need help in taking over for him. People can get that power, but it costs a lot to get it. If you do get a conservatorship, you have to report to the court on an ongoing basis. You have to give them accounting to show you're doing it right. It's a huge pain, and you want to avoid that. And again, you don't know who's going to be appointed as your conservator to take over your affairs. If you do a durable power of attorney, if you do a trust, you get to name the people specifically who will do it. And we are speaking about this community is very keenly aware of long-term care issues in working with home care assistants. A good power of attorney document should also contain provisions to allow the people named to take steps to plan for your long-term care if needed. And that just means making sure that you have money around. If you do need higher levels of care in a nursing home, helping to make sure that you can take advantage of Medicare in the United States, or in California, Medi-Cal. That's a whole other issue, but there are ways that you can protect your house and other assets and get help from certain government programs if needed by taking the right steps. But it's very important that your durable power of attorney document contains some provisions to empower the people named to do that. And I don't want to get too much into the weeds, but that can be a very valuable thing, and you can keep assets available to pay for home care assistance and other supplemental services while getting help to pay for nursing home care or other very expensive medical costs. So again, durable power of attorney overlaps a bit with your living trust. Very important. This names the individuals who can take over for any financial affairs that your trust doesn't cover. So let's move on to the Advance Healthcare Directive. So I think this is a somewhat new document. I think some people, I'm sure many of you might be aware of a durable power of attorney for healthcare. That used to be the document that would manage your healthcare decision making. That's no longer the case. Now we have advanced healthcare directives, at least here in the United States. Again, for any Canadian listeners, there are different terms for these documents, but the concepts are the same. I know in Canada there are versions of durable power of attorney and advanced healthcare directives. Extremely important no matter where you are. The Advanced Healthcare Directive, similarly to your trust, similarly to your durable power of attorney, this names the individuals who you authorize to make healthcare decisions for you. It can include a HIPAA waiver. That's the patient privacy law here in the United States. It allows the individuals named to communicate with doctors, to communicate with hospitals on your behalf, and really to make decisions for you if you're in the hospital and you can't communicate for yourself. We have the Dilbert cartoon here, and I think that's actually relevant because it does, a good advanced healthcare directive can deal with end-of-life situations. And in that way, you can take a massive burden off of your loved one's shoulders by telling them ahead of time and communicating in this document what you want. So a big part of the discussions that we have with our clients when it comes to advanced healthcare directives is around end-of-life care. If you're in a coma, if you're in a persistent vegetative state, what do you want? Do you want tube feeding removed? Do you want it to continue? This is where you see a lot of high-profile court cases. I believe Terry Schiavo that made national headlines in Florida. That was a case like this where I believe she was in a persistent vegetative state, and there was battles between the government and her family over whether they should let her go or not. In the Bay Area, there was a young girl named Johnny McMath who tragically, I believe, was getting her tonsils out, and something went wrong in the surgery, and she went into a persistent vegetative state, and now there's a huge battle as well. The family wants to keep her. The state of California has refused to keep her alive, so they moved to New Jersey, I believe, where New Jersey is now paying for her care. Now, she's a child, so she probably wouldn't have an advanced healthcare directive yet. But the point being, if you have one, you're not only naming the individuals who can make healthcare decisions for you, but ideally, you're communicating what you want if you are in these specific end-of-life situations or not end-of-life. It might just be if you're out of it for a while. Do you have strong feelings about painkillers? Do you have strong feelings about experimental treatments? A good advanced healthcare directive should cover a lot of this. So again, it's about empowering the people who you want in your life and who you want to be making decisions for you, rather than leaving it up to a court to do this. So let's go on to the next slide. I think, there we go. What happens if you don't have these documents? I've talked about this for the last few minutes as we've gone through them, but let's imagine a situation where you're incapacitated for whatever reason. That can be an accident, you're in a car accident, or you have a serious medical issue or dementia. You know, I think in the home care assistance community, I'm sure many of you are dealing with a loved one who has dementia issues and needs ongoing care. Maybe they can't care for themselves. Sometimes people have a dementia and they're kind of aware of it and just know they can't manage for themselves. So they still want someone else involved. What happens if you don't have a trust, if you don't have the power of attorney, if you don't have an advance directive? Well, again, your loved ones would have to go to court and they would have to get a conservatorship to manage your affairs. As I mentioned, it's a difficult process. It's very expensive to go through just because you need legal help. The minimum fees are high because a lawyer has to spend a lot of time on this, and they have to go to court with you and help you out. Ongoing court reporting is required. So once a conservatorship is in place, that's not the end of it. You have to continually provide accountings to the court, report back to the court. Basically, the court is looking over your shoulder as you do things, which is, there can be some positives out of that. You can make sure there's no abuses happening. But on the flip side, if it's family, if it's people who you trust, it's just a burden. You know, it's something you just don't want to face. So an ounce of prevention here is better than a pound of cure in this situation. So again, setting these documents up ahead of time can avoid all of that. So the critical choices to be made when we talk about these documents, they might seem a little bit overwhelming. You know, I talked about the different powers you can build into your power of attorney document or the different choices you make in your trust. But really, the most important decisions come down to two key ideas. Who do you want in charge of your care, and where do you want your stuff to go? Who you want in charge of your care is probably the most important thing when it comes to the power. I mean, that is all you really think about in the power of attorney in the Advanced Healthcare Directive. Is that a family member? Is it a friend? Is it a third-party professional? Who do you really trust? And what we always talk about when we meet with clients when they're unsure of who to name, you know, let's say they have 3 kids, and one kid is great but bad with money, another kid's great with money but not good with people, whatever. Or they have no kids, but they have different types of friends. You know, we always say pick someone who's obviously who you trust, but also someone who's very organized and responsible. They don't need to understand the legal issues that go into these documents. They don't need to understand your finances. They can use your assets to get help. You know, if you're named as a successor trustee, or if you're named as someone's attorney in fact, you are almost always authorized to use money for the person you're helping to hire professional help, to hire an accountant, to hire a financial advisor. So it's really something that's important to think about. And this is where those conversations with multiple generations, with your friends, with your family, are so important and can be so valuable. By communicating ahead of time, sometimes that can solve problems before they come up. You know, so we have clients who are worried, well, what if I name one kid over another? Well, will that child be pissed off that I named his older brother first? Well, if you talk to them ahead of time and say, look, I'm just doing this, I think you're all equal, I just want to name you in the order of age. Sometimes just explaining your logic there can be enough. So again, it's just hugely important to think about this ahead of time. And this is one of the key decisions you're going to make. And of course, where do you want your assets to go? 2 things I'll flag that come up a lot. What if you have children that are under 18, and you know, what if something happens to you before they're adults? It's very important to build in restrictions or ways that money can be controlled for their benefit before they reach a certain age, so they can't blow all that money while they're 21 years old. If you have a special needs child or a special needs relative, someone with a disability, very important that you speak to an expert about the idea of a special needs trust. Again, that's outside of the scope of this talk, but that's a really important concept. You don't want to leave money directly to someone who relies on government benefits for a lot of reasons, but just another key thing to think about if you do have any special needs children and relatives. There are a lot of other advanced planning tools that are available, and an attorney can help you with those, but these are the big two decisions. You know, where do you want your assets to go, and who do you want in charge? Good. I'm trying to go. There we go. Let me just quickly hit on long-term care. Again, I think that's very relevant, especially to this community. Something that everybody here is familiar with, because if you utilize home care assistance, then you're utilizing long-term care services. Or if you're part of the home care assistance company, you're providing long-term care services. So as many people I'm sure are aware of, the cost for long-term care can exhaust someone's estate. You know, the cost can go anywhere from $2,000 to $15,000 a month per person or more. We have a client couple who is spending $500,000 a year on long-term care. That's the far end of the spectrum, and they're at a great facility and they get 24/7 care. But the point is, it can be very expensive. This is all part of the estate planning process, just to become aware of this and to talk about this with your family. You know, what can you rely on? Well, obviously on the services side, if you need care at home, you get help from home care assistants, and then there are other service providers in different areas. But then how do you pay for it? You know, so one thing to think about, there's another good excuse to revisit these issues. If you're thinking about estate planning, maybe you look at long-term care insurance. I know home care assistance is very helpful in coordinating claims with long-term care insurance providers, but often that can be a great resource if you don't want to worry about saving up enough money to pay for it yourself. In the United States here, if you're a veteran, there's the aid and attendance program can be available. Here in the United States, there's also Medicaid, or in California we call it Medi-Cal. Very strict eligibility rules. You have to have a very small estate, but that can help to pay for nursing home care at least. So it's becoming aware of long-term care issues is very important in how you're going to pay for it. And again, sometimes the estate planning process, creating your trust, your power of attorney, your advanced healthcare directive, can be a good excuse just to revisit these issues and to think about them and to communicate with your children or grandchildren about what you have and what you want for care, to just make them aware of the resources available and the types of care that you want down the road. And again, having documents in place is a good way to make sure that your assets are well managed. Because again, if you have to get a conservatorship, or if you don't name the right people in your planning, money can be wasted and it can be frittered away. Or maybe the wrong person gets access to your money and starts blowing it. You want to make sure that the right people are involved and your money is well managed so you can get the care that you need. All right, common objections and challenges. Why do people not put these documents into place? Well, you know, it seems like kind of a downer. It's thinking about death. It's thinking about painful legal issues. Thinking about paying a lawyer or another expert. So again, I think some of this is maybe from my non-lawyer background, but I encourage people to think about it differently. Ideally, this should be a positive process where you think about your hopes and your dreams for yourself and for your family. You know, it's about the legacy that you want to leave, and it's a great excuse to talk to your family about your values, about your goals for future generations. It could be a chance to talk about how you'd like to help future generations. Sometimes talking about what you're going to leave to your kids or how you want to help them can be a very positive thing. It's not all about trust fund kids. It can be about showing that how much you have, the types of care you want to get, whether or not you're going to need your kids involved in the future to help you. But really, it's a chance to talk to your family about what you're worried about and how you hope they can be involved. And most families that we work with, it makes a lot of sense to bring multiple generations together. If there's conflicts between kids and parents, or one sibling doesn't get along with the other, sometimes that doesn't work. But most of the time, this can be a great excuse to bring a family together to talk about these issues in a positive way and really to turn your fear about the future into hope, which is really how it should be. So we're coming up on the end of the 45 minutes. Just a couple other points I want to make here. So what do you need to do? What should you do right now? You know, we've talked about all these things. You have these ideas. You hopefully have some decent understanding, at least, about the basics of these documents. Now, I went through these very quickly, so don't feel like you should understand these in some deep way. It's okay if you don't. As long as you're just familiar with these documents and the very basics of what they do, you're in good shape. But now that you're thinking about this, take action. Planning ahead is so much easier than waiting till the last minute, or if you're facing some horrible medical issue or a family crisis. Doing it ahead of time is so much better. Again, have a conversation with your family. If you did documents a while ago, revisit them. And I really encourage everyone here to do this with an attorney. LegalZoom, there are a few other online services. There are even very cheap attorneys. We see ads for $5.99, all-you-can-eat trusts and power of attorney documents. They can be okay, but they are not going to get beyond the very surface level issues. LegalZoom doesn't really provide you any guidance. They provide you minimal guidance. But a lot of these concepts, you really do need to speak with an expert to really understand what they mean. So very important things can be left out if you're not working with an attorney who specializes in this area. If you're in the Bay Area, in Northern California, of course, we could help you. But regardless, I would say while this is top of mind, this is a great excuse to reach out to an attorney. The National Academy of Elder Law Attorneys can be a good resource. NALA, I believe it's NALA.org. It's an organization actually my father helped to found. It's an association that only includes attorneys who specialize in elder law and estate planning. That can be a good resource to find someone who knows what they're doing in this area. Just really quickly, there's a couple books that our firm has published that I've co-written, that Michael Gilfix, my father's written. I don't want to spend much time on these. We have a book on estate tax planning. We have Facing the Reality of Long-Term Care. It's a book that really delves into long-term care planning and the issues around that. We have a book on special needs trust planning. These are all available through our website. If you're interested, you can learn more at gilfix.com. But with that, let me wrap this up. A couple minutes behind, but I think we stuck to the schedule pretty well. So thank you so much. Again, our website's gilfix.com. I'm getting more active with Twitter. I intend to keep track of developments in this field. You can follow me on Twitter at Mark Gilfix, and you can contact me through our website as well. So with that, thank you so much. Let me turn it back over to Catherine, and we can go into some questions.
Great. Thank you so much, Mark. That was very informative and it was an excellent presentation. We have a lot of questions coming in. So just a reminder to everyone on the webinar, if you have any questions, you can type them into your chat box, and we will take this time now to go through a Q&A. So.
Right.
First question, we always get this one. Will your slides be available for download? And yes, we are recording this presentation, so I will be emailing everyone who signed up for the webinar, and you will have access to the recording of Mark and the slides. Next question, what is the best age to set up a trust?
That's a good question. There's really no right answer to that. It depends on your situation. So I think, excuse me, most importantly, if you have kids, that's the time to do it. So we have clients that range the spectrum from late 20s even, and then all the way up to 90s. We have clients who are in their 90s who have substantial estates who had not set up a trust. So there's no right age to do it, but certainly, when you have kids, I think that's a really important time to do it. But the sooner the better. But I think having kids is a great marker in your life that should be the kick in the seat of the pants to get it done.
Thank you. Next question. Should a trust be contingent beneficiary of 401k, assuming that the spouse is the primary beneficiary?
So the question is, okay, so retirement accounts. I didn't go into too many details about the types of assets you have in a trust, but this question very smartly refers to the fact that your retirement accounts are outside of your trust. Assets in a 401k or an IRA, they go to whoever you list as your beneficiaries, your contingent beneficiaries, or after you pass away. They don't go through probate. They're not subject to that, and they don't go into your trust. Can you name your trust as a beneficiary after your spouse? You can do that. Typically, we recommend that if you have kids, after naming your spouse, you might just want to name your kids. This gets into some very nitty-gritty income tax issues that I won't get into too much detail here. You can name the trust, but typically we recommend actually just naming individuals after your spouse, but the trust can be an option. But that does get into some tricky secondary issues, so I'd encourage you to talk to a tax expert about the trade-offs on that.
Great, thanks. Next question. What happens when a house is put into a trust name as far as frozen property taxes for seniors? Can they still get this benefit?
Yes. So the transfer of a home into a trust is an exempt transfer. It's exempt from a tax reassessment. So it should not cause an increase in your property taxes, especially here in California. With Prop 13, for those of you listening in California, that's a huge deal. Some parts of the country it might not be as big a deal, but you don't want your property taxes reassessed. The transfer of a home into a trust is exempt from taxes being reassessed. So, and again, this also speaks to the importance of doing this with an expert, because in doing that deed, you have to fill out some additional paperwork with the county to show them that it is indeed exempt, and you want to make sure that's done right. Because if you don't do it right, it can result in a tax reassessment. Sometimes you can fix it, but you want to do it right the first time. So that's the long answer. The quick answer is it should not affect your property taxes.
Thank you. Next question. For low-income clients who can't afford an attorney, can they put these documents together without an attorney? Can they draw them up and simply have them notarized?
Yeah, so if you are lower income, there are different limits for probate, by the way. I didn't address those directly. In California, if you have an estate that's worth less than $150,000, you actually don't need to go through probate. So you technically don't need a trust. And in that case, a durable power of attorney likely would be enough to provide some lifetime management benefits, and it would likely be enough to prevent a conservatorship. So you have if you're low income, if you have a smaller estate, sometimes just a power of attorney and an advanced healthcare directive can be enough. And you can indeed do those without attorneys. An advanced healthcare directive, we advise that they're done with attorneys, but those often are done without them. Some medical centers, in California we have Kaiser Permanente, will help you to fill out an advanced healthcare directive. That's certainly valid with them. You don't need an attorney for that. A power of attorney document, for basic stuff, you probably can do that without an attorney's help, and just getting it notarized is enough for it to be valid. And even doing a trust, if you have very simple circumstances, you can do them online or without an attorney. We don't recommend it because minor mistakes can cause big issues. But if you have a smaller estate and don't have much income, then these issues are not as big. You're not quite as worried about them. So absolutely, you can do them without an attorney. There are also sometimes free legal aid programs that will help for low-income people. For example, I believe SALA here in the Bay Area, Senior Adults Legal Assistance, will provide guidance around that, the organization that my father started. So you absolutely can do it without an attorney. It is important to get it notarized, and it's certainly a lot better than not doing anything.
Thank you. Next question. I have an LLC that owns property. Can the LLC ownership be put into the trust rather than renaming the properties to the trust?
Absolutely. So there are a lot of good reasons at times to have an LLC that holds property. There can be liability protections. There can be tax benefits. You absolutely can, rather than putting property into a trust, you can simply put LLC shares or the entire LLC into a trust. So the answer is yes, you can do that, and many of our clients do that.
Thank you. Next question. We are frequently asked about Medi-Cal estate recovery. One person said a lawyer told them to do an irrevocable trust to avoid recovery, but you explicitly said to do a revocable trust. Can you speak to this?
That's a great question. And so the advice you got was actually right. And we help a lot of clients with irrevocable trust. I guess to paint a bigger picture, the documents I talked about are really the baseline documents. These are the ones you need to have in place no matter what. But if you are in a situation where you need Medicaid or Medi-Cal here in California, and these are programs where you have to show that you have under a certain amount of money, then you get help paying for nursing home care, your home is exempt. It doesn't count against asset limits to be eligible, but if you don't take the right steps, the state can and will seize your house to get paid back after you pass away unless you, again, take the right steps. So we do recommend, and we help a lot of clients in this area, we do recommend that in many cases you do create that irrevocable trust to hold your house. It's a whole other area of law. Well, it's the same area of law, but we don't have much time to go into that. But you absolutely can do that. That would be a separate trust. So if you were worried about this, you would create this irrevocable trust. You keep your living trust for some of your assets. You would then transfer your home, though, into this special trust to protect it. But that's only something that you would do in a specific circumstance. So that's something you want to speak to an expert about it if you needed to deal with that. You wouldn't do that way ahead of time. So you would still want to have a living trust set up in place before you face all that. But a living trust gives you maximum flexibility to plan for these different situations down the road, including setting up an irrevocable trust to hold your house. But again, that's only something that comes up in specific circumstances.
Great, thank you. Next question, what's the typical average cost of setting up a living trust, say in California, if it differs by state?
That totally varies by the quality of the attorney or the service that you use. I can't speak to what every attorney charges. You can get really cheap ones. I see ads for some where they say, $800 for a living trust flat fee for an attorney. I don't think those are high quality services. For someone to work with us, if it's a family they don't have enhanced planning needs, typically the fees to set up an entire estate plan that includes meeting with us, going through things in detail, making sure that we're covering every need that you have, is around $3,000 to $4,000 to do everything. It can be less. Sometimes it's more if there are other needs. But again, spending a little bit of extra money early on and working with someone who knows what they're doing can save tens of thousands later. It's a great investment. So the cost can vary, though, totally. I think in some states, I would imagine it's a bit less. I just don't have much context. I know of attorneys in other states that charge up to $10,000 to do estate planning, who are more high-end, and then we know of some that are very low cost. I think you really don't just shop based on price, would be my main point. Make sure it's someone who really knows what they're doing, who's been in the community for a long time. It's easy to look pretty good online and even to get good Yelp reviews. We see firms that we know don't really know what they're doing, but they get great Yelp reviews because they make people very happy. They smile because they don't pay much and they're very nice to them, but their documents aren't very good. So don't just look at Yelp. Try to get help from people who know what they're doing. But anyway, the cost can range pretty widely. I think anywhere from $2,000 to $5,000 to set up an estate plan is probably a pretty reasonable range, maybe less in other parts of the country.
Thank you. Next question. If your parent doesn't have funds or property, do you still need a trust to be able to handle the medical issues that come up with your parent, or is the power of attorney enough, or is something else needed?
Yeah, so if your parent doesn't have much in the way of assets, often a simple will is enough in that case, but then it's very important to have the durable power of attorney and advanced healthcare directive in place, especially in the medical context, the advanced healthcare directive. So if your parent doesn't have much, and we have clients who come in and their parents have hardly anything, you still absolutely want to create the advanced healthcare directive and durable power of attorney for them. But in that case, a will might be enough. You're not worried about probate because they might have a very small estate. So a trust might not be needed, but certainly advanced healthcare directive and durable power of attorney.
Thank you. I believe we have time for one more question.
Right.
So I'm going to go to this one. What can one do if they notice a family member is starting to decline and they want to help them get their documents in order before it's too late?
That's a great question. And that can be a tricky situation, because what if the person doesn't realize that their cognitive abilities are slipping? the best thing you can do is communicate with them. You can absolutely help start the process. We have relatives who will bring a family member in to see us. It's okay if you bring them into the attorney. The key thing is that the attorney really does have to meet with them one-on-one to make sure that the documents reflect their wishes and to make sure that they have capacity to do documents. One thing I'll point out is the rule for capacity, your ability to create documents, it's pretty flexible. The law is very protective of one's ability to make decisions. So even if someone's cognitive abilities are slipping a bit, and I know home care assistance offers some great programs around some cognitive therapeutics, even if they're slipping, they still likely have the ability to sign documents. It's really, as long as you understand the basics of who's around you and what you have, and have a basic understanding of what you're doing, the law respects your ability to create documents. So talk to someone. It's totally fine if you help start the process. You can even help them, bring them into an attorney's office, but it is very important that they meet one-on-one with the attorney at some point. Communication is the key, though. Talking to their family, talking to their loved ones, and talking to them, because doing it before their ability really slips is a lot easier than waiting till it's too late, in which case, again, you have to go to court.
Well, thank you so much, Mark, for taking the time to give us this great presentation today and answer all of these questions. I think that concludes our webinar for today, and hope everyone has a fantastic day.
Great. Thank you guys
Bye-bye.
so much. Bye.